21 CF 1179. Appearances, please.
William Brown, State of Wisconsin.
Walter Johnson appears in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Your Honor, we are unaware if Mr. Johnson is eligible for public defender services. As of right now, we believe the best address for mail would be the Dane County Jail. In addition, we have received a copy of the criminal complaints. We will waive their formal reading and stand mute to any misdemeanor charges.
All right, thank you. My understanding is that Mr. Johnson is in custody on an probation or parole hold stemming from a branch 15 case. That would mean that these new cases should be assigned to Judge Highland in branch 14. Mr. Brown, any position regarding bail in these matters?
Sure. Given I'll start with case 21 CF 1178. Obviously, the charges in that case are the most serious.
Your Honor, Jessica Delgado from the DA's Office, Victim Service. Would you like to hear the victim's recommendation, or should I wait to speak?
I think now is fine.
Sorry about that. So Jessica Delgado from the DA's Office, Victim Service Program. Victim ARJ wishes for her statement to be on record. She opposes the no contact and wants to be able to have contact with defendant by phone while he's in custody.
All right, thank you, Ms. Delgado, I appreciate it. Mr. Brown.
Sure, and I appreciate that too. Again, starting with the most serious case, the state's going to request $100,000 in cash bail. The defendant here is facing over 30 years in prison, being charged with operating a motor vehicle while suspended, causing the death of someone, homicide by use of a vehicle, by use of a controlled substance, and obviously operating with a restricted controlled substance in his blood. The criminal complaint spells out fairly well what happened. Mr. Johnson was driving at an extremely high rate of speed. I use that phrase vaguely because the State Patrol is still conducting its analysis, but there were some modifications done to the car. So while there is computer data as to what the speed was, because the tires were modified, some additional testing has to be done. But at least witnesses put the car going in excess of 80 miles an hour on one of our 55-mile-an-hour stretches of road. Witnesses report the car going airborne at one point, flying across the lane. And obviously a child was ejected from that vehicle along with Mr. Johnson, causing the child's death. That young person was only 16 years old. Mr. Johnson's got a very serious criminal history going back to 2005 with burglary, car thefts, fleeing and eluding, drug crimes, again in the early 2000s, fleeing, eluding, burglary, domestic charges, robbery charges, in which he went to prison for, and I believe was on extended supervision for quite a long time. In Sauk County, several domestic violence charges, all pending, or all that happened in 2019. At the time of this offense, he was on active supervision by PNP. I did take a look at their law enforcement data today in preparation for today's hearing. He was absconded. He was in absconder status since January, I believe, of this year. Ultimately, yes, it was January 24th of 2021. The U.S. Marshals ultimately were able to find him and pick him up on the 19th of May of 2021. So obviously trouble following court orders, and the fact that he was having trouble following the rules of his supervision. He obviously knew that this was something that he was being looked at for. He was, of course, involved in the crash and injured severely himself, but he was a family member or a close person to his family that did die in this crash. And so he knew that these charges were possibly coming and was absconding from PNP at that time. In that case, I would ask the conditions be that he not have any controlled substance or alcohol. While there's no alcohol test at this time, there were alcohol bottles found in the general vicinity of the crash scene. And I think that provision would be appropriate considering the facts at issue here. The other case that's set today is obviously, in terms of severity, much less, but I will go ahead and read those bail condition requests. Give me one moment. In the case ending 1179, the state's requesting $3,000 cash bail, no contact with Andrea J. Or Jordan R. And a ban from their residence. Thank you.
Okay, thank you, Mr. Brown. Mr. Wyndham.
Your Honor, we'd be seeking a more modest amount of cash here in relation to these circumstances. First, we'd like to note the offense date in relation to Mr. Johnson's, in relation to the 21 CF case. The offense date is listed as September 4th of 2020. That's nearly 9 months ago. In relation to the circumstances here, Mr. Johnson was clearly injured in relation to that accident. He was not brought into custody till now in relation to those circumstances. We do note and note the need for cash bail in relation to these circumstances. We just believe that the $100,000 mark is a bit excessive in relation to the circumstances. We believe that amount in the in the range of $20,000 would be a more reasonable amount of cash bail, something that is potentially obtainable, but for the most part is a significant amount of cash and would ensure Mr. Johnson's appearance in court. As far as bail conditions in relation to that case, we would have no objection to the no alcohol or drugs and the not operating a motor vehicle in relation to that case. In relation to the 21 CM case, we believe that a cash bail in the amount of $250 would be appropriate given the misdemeanor nature of these cases. In addition to that, we believe that no acts or threats of violence would be appropriate given the statements made by Ms. Delgado here today, informing us of the victim's wishes. We are unaware if Mr. Johnson is eligible for public defender services, but due to his injuries, he has not been working. He has resided in Wisconsin all his life, and we believe that the more modest amount of cash is significant, to say the least, but it would be appropriate given the totality of the nature of these circumstances. Thank you.
All right, thank you. I do appreciate the arguments made on both sides because there is credibility to both of the arguments. There's plainly a need for cash bail and substantial cash bail. That's true given the nature of the charges, the history, the problems with absconding, and the extreme likelihood of a significant sentence in the event of conviction in these cases. It's an inexact science, to say the least, as to what a good amount of bail is. I tend to land somewhere in between the numbers that have been described in this case. I'm going to set cash bail in 1178, the homicide by intoxicated operation case, at $60,000. I'll order as conditions that he not operate a motor vehicle at any time, that he not consume any alcohol, and that he not use or possess controlled substances or drug paraphernalia without a valid prescription. In case 1179, I'll set cash bail at $2,500. I'll order as conditions that he not have contact with Andrea J. except by telephone, and that he have no contact with Jordan R. I think that appropriately synthesizes the various requests and takes into account the competing interests here, and they're all pretty legitimate. We should get prelims scheduled in the next 10 days on these cases. Oh, I think I failed to mention an address ban with respect to Andrea J. It is my intention to adopt that request as well.